Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Steve Barnes. In this episode, we'll examine the latest developments, trends, and threats in the areas of digital privacy and cybersecurity. We'll look at what we mean when we talk about our right to privacy, and we'll also examine some success stories in terms of how individuals, companies, and governments best protect their information. We're fortunate to have with us two experts to look at these issues. First, we have Anita Allen. Anita is Vice Provost for Faculty here at Penn, and she's also the Henry R. Silverman Professor of Law and Philosophy here at Penn Law. Professor Allen is also the author of the book Unpopular Privacy: What Must We Hide? We're also joined by Lisa Sotto. Lisa is Managing Partner at Hunton & Williams' New York office, and she's also the Chair of the U.S. Department of Homeland Security's Data Privacy and Integrity Advisory Committee. Thank you both for joining us. All right, so let's get right to it. Professor Allen, let's start off with what we mean when we talk about our right to privacy. What are the foundations for privacy law in America, and how does that inform how we think about our privacy online?
Thanks. That's an excellent way to begin with a question of what are our privacy rights in American law. And it turns out, Steve, that we have a huge number of privacy rights in American law. I think far many than most people who struggle with internet-type questions even imagine. For example, we have a whole array of federal statutes to protect interest in privacy that go back to 1974. I'll just take a second to mention some of those. We have our Privacy Act, which protects our privacy and government records. We have education privacy laws, nicknamed FERPA. We have financial privacy laws. We have health privacy laws, the HIPAA laws, which most of us are familiar with. We also have laws to protect our electronic communications, our emails, our voicemails, our telephone calls. So that's just the beginning, though, Steve, of what kind of privacy rights we have. In addition, every state has privacy laws as part of their state common law and part of their regime of statutes. So library records, for example, might be protected by state laws. But in the states, you have common law rights. So if someone invades your privacy by intruding upon your seclusion or publishing false information about you, publishing true information about you that is highly offensive, they can be civilly liable to you for damages. And then finally, in our Constitution, we have a famous lack of an explicit right to privacy. Everyone emphasizes the fact that there's no explicit written down right to privacy in our Constitution, but actually there are a number of amendments, Bill of Rights amendments and the 14th Amendment as well, that courts have come to recognize do protect interest in informational privacy and in physical privacy and in the privacy of choice and decisions. So we have quite a panoply, as you can see, of privacy rights.
So just as a quick follow-on, and Lisa, please feel free to offer your thoughts as well. How do you reconcile, if you will, the different levels of law, if you will, state, federal, and so forth, when trying to understand what an individual's right to privacy is?
Right. So you have to look at it in context. So, for example, if I feel that someone has inappropriately accessed my email, I have to ask myself, well, what federal statute might there be? What state statute might there be? What common law rights might I have? It's time to call a lawyer because lawyers today, like the one who's on this podcast with us, are familiar with privacy rights and can begin to orient an individual towards where to go. So if your email is accessed inappropriate, we have the Electronic Communications Privacy Act that addresses both wiretapping and improper accessing and obtaining of emails that belong to other people.
Great. Lisa, any thoughts on that?
Yeah, in the United States, we really think of privacy as a consumer right, which is very different from the way privacy is conceived in Europe, where it's a fundamental human right. So we are constantly in the private sector trying to reconcile the U.S. regime with other regimes around the world where privacy is considered much more of a human right than it is here.
If I could just add to that, because I think that it's absolutely true that we think about privacy as a consumer right, especially when it comes to financial privacy issues or video privacy issues and so forth. But I would underscore that if you go back in time to the beginning of the right to privacy in American law, back to the late 19th century when Louis Brandeis and Sam Morin wrote that famous Right to Privacy Law Review article and published it in the Harvard Law Review, back in those days, people talked about privacy in loftier ways that are not unsimilar to the way we talk about privacy as a natural right or a human right. They talked about privacy as a right that belongs to everybody naturally, not given by government alone, but also part of our moral fabric. And I think Louis Brandeis, when he became a Supreme Court judge, brought some of that spirit of privacy being more than just a regular interest, but a real fundamental right, a natural, a human. That's part of our way of thinking about it. And when the first U.S. State Supreme Court found a right to privacy, it was the Georgia Supreme Court back in 1906 in a case called Pavsich versus New England Life Insurance. The judge, Judge Cobb, he actually said that invading someone's privacy is like making them a slave to a merciless master. This is more than just a consumer interest, right? It goes to the core of who we are as human beings.
I want to get to that precise question in just a moment, but turning to you, Lisa, for a second. From the sort of well-covered celebrity photo leaks from a few months ago to the recent Sony and Anthem hacks, even to the alleged ISIS hacks on government social media accounts, there's been a steady drumbeat of news about these criminal acts, cyber attacks and cyber threats and so forth. From your perspective as an attorney who specializes in cybersecurity, in sort of general terms, how are these hacks happening and where are they originating from?
Yeah, a steady drumbeat is right. Really, we've seen a stunning series of events over the course of the past year. When we think of cybersecurity events, we think about really three buckets of bad actors. We think about hacktivists, and those are folks who band together for to pursue some loose ideological mission. They're anarchists who come together for some loose purpose. The second bucket is that of traditional hackers. Those are criminals who are seeking pecuniary gain. They're looking to steal data that they can sell on the open market that will benefit them financially. And the third bucket is known as APT, Advanced Persistent Threat. And these are nation-state actors who enter into systems, and sometimes they stay for years and years, and they commit cyber espionage or straight out theft, where they're stealing M&A information, R&D information, blueprints, and the like. They're getting in through lots of different means. One of the most popular ways right now is through social engineering, where the criminals will send a phishing email and somebody, inevitably, we're human, we will respond. Somebody out of a population of 1,000 will respond to that phishing email. They'll click on a link. Malware will be downloaded onto the system, and that is the way in. Or we've had some clients have this happen. Somebody calls an employee, and it is they say, "Hi, this is the help desk. Can we remote into your system?" And the very helpful person at the other end says, "Yes, of course, no problem." And they remote in, and they're in. And there's their entry into the system. And then, of course, there are the traditional ways of getting in through vulnerabilities, and vulnerabilities are rife right now. So we're seeing lots of compromised credentials as a source, system vulnerabilities where patching may not be done on a routine basis as it should be done.
So, Lisa, just to follow up quickly, again, in general terms, and obviously nothing confidential, but how do you advise clients, whether they're corporations or governments, to deal with some of these threats, both in terms of, if you can, talk a little bit about in sort of macro terms as well as micro?
Sure. So these are dealing with a major cybersecurity event is really a logistical feat because the way we start is we're notified often by the Secret Service or by the FBI. Sometimes we see an anomaly in the system, and that gives us the sense that there's something going on. Or we could be notified by a blogger, by Brian Krebs, for example, who's the very well-known now security blogger. Once we have some sense that there's something going on, then we immediately, as lawyers, retain a forensic investigator, and we do it through counsel to try to preserve privilege around the results of the investigation. as the investigation proceeds, which the lawyers are really intimately involved in and really directing the investigation and strategizing the whole way, we're also doing the legal analysis. Now, the legal analysis could actually be very tricky because if you're dealing with just U.S. residents, we have 47 state data breach notification laws plus 4 territories. Guam, U.S. Virgin Islands, District of Columbia, and Puerto Rico. And then overseas, there's this just real haphazard hodgepodge of data breach notification laws. So we need to understand the country of origin of the individuals whose data was compromised and then do the legal analysis. From there, we would draft the relevant documents, letters to the affected individuals, website materials. We would train the call center agents, deal with the PR firm and preparing a press release, and then we're ready to announce. And then following the announcement, of course, we then need to deal with the regulatory response. Inevitably, a regulator will come back to ask questions, whether they're state attorneys general, the FTC, or others, and then there inevitably will follow class action lawsuits.
Great, thank you. Did you want to add anything to that?
Well, just that, you mentioned that inevitably we'll follow class action lawsuits, and that actually does happen because now we have to worry about how the consumer and the individual has been affected by the breach, whether it's a hacktivist breach or a pecuniary breach or an APT. What does it mean for the individual? And some individuals feel like their privacy interests have been harmed by these security breaches.
Right. I want to get back to something you mentioned just a bit before when you were talking about Brandeis. So digital and mobile technologies have impacted, really altered how we think about our privacy. So whether it's hitting the agree button when accepting the terms and conditions of an app you've downloaded or music you're buying, is privacy less important to people now than it used to be?
Well, this question gets often asked, is privacy less important than it used to be? I don't think it is less important than it used to be, but I think that it's harder to understand the many ways in which our informational privacy is at risk. And so I think we tend to give it away or neglect it because we don't understand fully the ways in which it can be taken away from us or what we as individuals can do in order to protect our own privacy. We want to use our cell phones. We want to use our laptops. We want to use our computers, and yet we know that that there are these vague risks. We're not really sure what they are. So one point of view says, actually, privacy is as important as it ever was, but people are also very dependent now upon technology and cannot and do not know how to better protect their privacy. I think that there's not much evidence, if you look at the number of class action lawsuits or the number of privacy tort cases being brought, or the amount of chatter in the blogosphere about privacy catastrophes, I don't see much evidence that people actually have totally given up on privacy. There clearly are different contexts and ways in which our privacy can be invaded. People have different levels of interest in their privacy, but I don't think it's gone or that people have lost interest in it.
Right. Seems certainly on some social media accounts like Facebook and Twitter, they're certainly willing to overshare, but that's not quite the same thing. It's more reputational versus technological.
And there's a lot of what we consider oversharing on Facebook, on Twitter, but people have also learned to put on these fabulous masks. The person that's seemingly oversharing on Twitter or on Facebook may actually have a very thick and rich private life, which they don't want you to have access to, and you never will.
Lisa, did you want to add anything to that, or?
Yeah, sure, and completely agree. I don't think privacy is dead at all. I think it's just different. We used to think of privacy really as secrecy, confidentiality, and the most secret documents were secret because they were hidden away in a file cabinet somewhere that nobody could access. So we no longer live in that world in our digital age. But instead, we really think about control of our data, making sure that there's transparency in the ways entities use and disclose data, and trying to provide some modicum of individual control over that data.
And unfortunately, most people don't have a lot of control. And our laws are uneven in giving individuals the ability to control their privacy. A lot of the opt-in options or opt-out options people have to make choices, people don't really know exactly how to operationalize the benefit that those options represent. So I'm concerned about that. I'd also like to say that there is a respect in which the technology and the ever-present camera in our surveillance society is causing people to not respect other people's privacy as well as they ought to. So, for example, there was recently a case in which an artist used a telephoto lens to take photographs of his neighbors through their open windows. And it might seem to you and me that that's quite invasive, and the people who found out about the photographs were quite wounded. They went to court, and the judge, this is a New York lower court judge, actually said that the artist had a right to, under the First Amendment, to create art that superseded the privacy of his neighbors. And that's, to me, a stunning outcome, but it shows that, that we, while we value our privacy, we don't always value other people's privacy if it interferes with our artistic ambitions, our freedom of speech, and so forth. So we have to be mindful that one of the things which is happening right now is that while privacy is still alive as a value, and we value our privacy, we have to also make sure we value other people's privacy throughout the activities in which we engage, whether it's business or art or just simply freedom of speech, expressing our viewpoints in public.
Well, you mentioned that how people operationalize or not their privacy options, opting in, for example, on some things, maybe wittingly or unwittingly.
Yes.
One of the recent hacks, high-profile hacks, involved a hack of the cloud. And just to step back for a moment, Lisa, or you, please, Anita, the term the cloud is ubiquitous. It seems the cloud as a thing is ubiquitous, but just stepping back, what do we mean by that term? And what are the privacy issues associated with cloud computing, whether for the individual or for an enterprise?
Yeah, Steve, the cloud is absolutely ubiquitous now. What it really means is the use of remote computing devices to allow for centralized storage and online access to services. So it's not a very complicated concept, but it's an enormously efficient and effective way of dealing with data and services. So we are seeing really most of our clients going to the cloud in droves because it's just a lot cheaper and in many ways more secure. So we can secure our data and spend enormous resources securing our data within a particular entity. But in fact, cloud hosts, some at least, can do it better than we can within individual organizations. So back to your question about the legal issues, certainly security is a huge concern. The issue there is you're not holding your own data. You're not in charge of its security, somebody else's. So there's real fear. And of course, a cloud host is a treasure trove of everybody's data, not just the data of one corporation. So we think hard about security issues. We also have to think about the fact that there's a service provider in the mix now with respect to the data, maintaining the data. And there are rules in the United States with respect to service providers and the need for written contracts between the entity and the service provider in the healthcare context and in the financial context under the financial and health privacy laws. One other very significant issue that I'll mention is the ability of the government to get at data that's held in the cloud. So the government could, for example, issue a national security letter against a cloud host, and the cloud host must respond. There are criminal penalties if the cloud host does not respond to the national security letter, and the cloud host is not permitted to tell anyone, including the entity whose data is being disclosed to the government. So there's a real concern there that companies will not know if their employees' data is being turned over to the government.
The way I think about the cloud simply is as third-party entrustment. Lisa was talking about primarily the corporate entities that entrust data that belongs to them and to their clients to a third-party host. But individuals daily entrust their data to third parties, including Dropbox, for example. And she's right. I mean, the security issues are profound. The surveillance issues, the government access issues are profound. But people are putting their medical records voluntarily in the hands of a third party. They have very little control over that other than by the contracts, which they, in some sense, sign, but don't necessarily read or understand. So
The agree button.
The agree button, yeah. And everybody, including myself, loves the ability to upload their information to the cloud because we know that our laptops are vulnerable to coffee spills or whatever, and we really want to keep our data. We have many more photographs than we can keep on our iPads without compromising our space. So there's lots of reasons to use the cloud, but there are these privacy and security risks which go along with using the clouds.
What are some of the key issues to be aware of as a consumer in terms of how companies track and then possibly market to you?
Well, when we use Facebook, for example, or LinkedIn, or any number of internet-based, web-based services that are, again, very useful to us, there are questions that sometimes arise about whether or not the data that we've entrusted to these organizations are being used for data analytical purposes, for marketing purposes, and it's very valuable information. So there's a temptation, indeed it's quite rational, to try to make use of the data if you can within the bounds of the law. So what can individuals do? How can individuals keep track of this? One thing you absolutely must do is consumers must be more mindful of what they are agreeing to when they sign up. And then they must hold the companies to the agreements. How can they do that? Well, it's very difficult as an individual to do much of anything, to be perfectly honest. I know I've tried to get stuff taken off of MySpace, remember MySpace and other, it's very difficult to get stuff taken down. Among the resources that the public has to deal with improper accessing, breaches of contract by service providers, and by content providers, and by social networking providers, is to marshalize their rights under the FTC. The FTC has been very aggressive.
Federal Trade Commission.
Federal Trade Commission has been very aggressive about trying to hold organizations to their commitments to consumers. It's an unfair trade practice for a company to say, I'm going to do X and then to do Y. I should say, I'm going to do A, then do B, C, and D. And so hopefully the watchdogs out there, including our federal watchdogs, will be helpful to us in helping us as a group to protect our rights. But individuals have to rely upon old-fashioned telephone calls and letters of complaint and dogged kinds of consumer action measures as individuals, and it's very difficult to make much headway in that area. I do think that one thing that can be done is if you expose what's happening, if it's written about, talked about, discussed publicly, companies will sometimes be shamed into changing their practices and policies or clarifying the language of their agreements to make sure that when we press that button and say, I want to join up, or press that button and add more data to our profile, that we know it's going to be secure and private.
So if you could please, talk a little bit about the right to be forgotten. What does the term mean? Where are we now in the U.S. with this term? And also, what's been going on in places like the EU in terms of how the right to be forgotten has been implemented?
So for many, many years before the internet and the web, we all enjoyed this thing which one of our courts called practical obscurity. There was a lot of information about us, but it was all on index cards and in paper folders, manila folders in offices all over the country and all over the world. And we knew that because it was impractical to access that data, we actually enjoyed quite a bit of privacy with respect to things which happened to us in the past, which we might not be proud of, including some of our criminal histories. But nowadays, there's no practical obscurity of data. Everything can be Googled, everything can be discovered. And so the right to be forgotten is a concept which has emerged because people have realized that they don't want the tracks and trails of their every move to be kept forever. We want some of our misdeeds, even some of our positive deeds, we'd like to just push in the background. We want to move on. And it's very difficult to do that when people can press buttons and uncover everything about you, where you used to live, where you used to work, all the things you've done. So a lot of us feel as though there should be, as a matter of law, a right to be forgotten. One of the ways this can be made practical is that if companies, for example, required by law to delete records after a certain period of time. We do have a federal statute called the Video Privacy Act, which does have as part of it a provision requiring that after a certain number of years, the company delete your records. Now, when our video was, video providers were Blockbuster on the corner store, it's easy for them to go into their computer and erase the records, and that was fine. But with companies like Netflix, it's much more complicated because in a way we want them to keep track of what movies and documentaries we've seen over the years. We don't want them to forget because we want to remember. So there is this interesting idea here that, on the one hand, we would like to have our past, especially the bad parts, forgotten. We also have an interest, to some extent, in keeping information alive. Now, on the international level, in Europe in particular, there's a discussion about the right to be forgotten. And there are now actual concrete legal provisions and policies in place and being discussed that make the right to be forgotten part of the law of our informational privacy. I don't know exactly where things stand in Europe right now, but I know there's been a lot of discussion and some concrete movement towards creating a positive law right to be forgotten. In the United States, we don't have a right to be forgotten, except that a couple of statutes, like the one I mentioned, have provisions that require companies to delete our records after a certain period of time.
Great. Lisa, your thoughts, if you would like?
Yeah, the right to be forgotten is a laudable concept that's virtually impossible to actually implement in the digital age. I think we have to think very, very hard before we start to encode this concept into law. And in Europe, we're seeing the ramifications of that, where people are being allowed to ask Google and Bing and the other search services to take their data off. Particularly, of course, they want that done when it's negative, but that's the data that others may want to see, like credit records, items that really would be important in making certain decisions about people.
And just to follow up on that, I do think that it's one thing to ask, say, Facebook to take down my Facebook page and that way create something of a right to be forgotten. It's more difficult to say to Google, remove all traces of me from your search engine, because the traces of you are so varied and it's difficult as a practical matter to do it. I think the question of whether people shouldn't have a right to be forgotten is a very interesting one. And there are legal theorists, like Judge Posner, for example, who've argued that people don't have a right to secrecy with respect to things about them which other people need to know to protect their interests. So if you've committed a crime or you have some financial misconduct in your past, question, don't people have a right to know that so they can protect themselves from you in the future? So there's this tension between what interest the individual might have in being forgotten and the interest others may have in knowing about their past.
Great. Lisa, so you talked a little bit about some of the challenges, especially in the realm of EU laws. So what are some of the key differences between the United States and Europe in terms of privacy and cyber laws? And how are companies dealing with these differences or conflicts in laws?
Steve, that's the $64,000 question. The laws are really very different, and a global company finds it extremely challenging to navigate the global landscape because, of course, the very same data set could sit in one jurisdiction, 16 jurisdictions, or 52 different jurisdictions, and different rules apply to that data set, which makes it really, really hard to deal with this panoply of laws around the world. So let me speak for a second about the difference between U.S. and EU law in particular, and I'll take that even further and venture to say that EU law is really now being it's being picked up by many different jurisdictions even outside of the EU. So in the US, we think of privacy in terms of sectoral laws. We have a financial privacy law, we have a health privacy law, we have a privacy law dealing with kids' data online. We have, as Anita mentioned, a privacy law dealing with video protection of video rental records. So we think of privacy in terms of industry sector or particular data types. In Europe and in many other jurisdictions overseas, privacy is really considered in terms of an omnibus comprehensive single law. And that law deals with data in any format, any type of data that relates back to an individual, an individually identifiable human being. So in Europe, they have this comprehensive regime. Here we have a sectoral regime, very different in approach. One is not lesser than the other, I would argue. Some would beg to differ, but but I think they're really very different. So how do we deal with that? We really try to take the high road. So when we're working with our clients to try to figure out how to manage these extraordinarily different data protection regimes overseas and in the United States, we think about privacy by design. And that means embedding privacy and embedding the fair information practice principles, which undergird every privacy law around the world, into a new product, into a new technology, into a new marketing scheme right from the start. So we're not retrofitting for privacy, but we're thinking about the privacy protections right from the start of a new product, a new technology. And we're particularly focused on how to provide appropriate notice and choices. We think about rights of individuals to access their own data and to correct inaccuracies in the data. And we also think about enforcement. Is there an appropriate place within the company that will receive complaints and will deal with complaints? And what is the enforcement scheme within the company and then outside the company, of course, if things go totally awry?
That's absolutely correct. I do think that this debate in the universities, in the academy, among scholars about whether the European approach, the omnibus approach, is superior to our more sectoral approach has been a fundamental one and an important one. Lately, though, I think scholars have come to accept that the systems are just different, and we need to find ways in both contexts to make sure that appropriate privacy interests are well protected. And everybody agrees that privacy by design, which is to start off in building systems and building companies with privacy in mind, is a very good idea, as well as adhering to fair information practice standards. And fortunately, the Fair Information Standard ideals were part of the Privacy Act that was adopted in this country in 1974, and all subsequent federal privacy statutes from the Children's Privacy Protection Law online to HIPAA and FERPA and everything in between. All these laws do reflect to some extent fair information practice concepts. Notice, consent, transparency, accountability, these are very important principles. And so we could debate theoretically whether Europe has a more human rights approach to the United States or whether they're better than us. But I think what's key here is what kind of protections do we have? We do have, I think, analogous protections in both contexts. We're doing pretty well with what we have. We could do a lot better.
So we've talked a lot about problems and challenges with privacy laws here, whether for individuals or companies. Are there privacy law success stories? What is working well in your opinion?
I think that many people point to the Children's Online Privacy Protection Act as a success story. You know, this is a law which prohibits website operators from collecting personal data from children under the age of 13. That law radically reduced the number of internet operators collecting personal information from children under 13. The problem with the law, though, is that our young people now have so many different ways to access data that it's very hard to think that a law that was passed at a time when the model was one desktop computer in each home, child sitting there going to Disney.com or MileyCyrus.com. That's not the world of children anymore. So the law, I think, though, has been quite successful in sending the message that it's not appropriate to collect personal data from kids. And the law has been amended to take into account some of the newer ways in which children get access to information, including using their own personal cell phone. So that law is, I think, the closest to a success story. I think that despite all the complaints about HIPAA, the Health Information Privacy Law, that HIPAA has at least raised consciousness in America about the importance of health privacy. Yes, the law doesn't have a private right of action for consumers. They have to rely upon the government coming in and sanctioning and inspecting the healthcare, the covered entities. But still, I think having an opportunity to think about privacy each and every time you go to the doctor, go to a new doctor, and having to sign a document affirming that you're giving your privacy, health privacy, to the insurance company or to the hospital or to the doctor. Those exercises, while they're not perfect, they do at least keep privacy in the forefront of our thinking about health privacy. Just one more example. I think that the Electronic Communications Privacy Act, which has three parts to it, a wiretap protection, a stored communications protection, and a PIN register protection, that statute It's out of date because it was written in 1986, before we had the web as a part of our daily lives. But still, knowing that there is a law out there that keeps a little bit of a barrier between our personal conversations and the government or our neighbors, our email and voicemail and our neighbors and the government, and our telephone calls and our Skype communications. All these things are protected by this statute. And the statutes are widely criticized because they're old and they don't specifically reflect today's approaches to internet service providing and communications. It's still the case that those laws are working well to establish and affirm the right to privacy and to put a little bit of a barrier between ourselves, our neighbors, and our government.
Steve, I'll chime in on that as well. Let's talk about what are successful concepts in privacy laws. I think transparency is a really critical concept. People ought to be able to understand how their data is being used and to whom it's being disclosed generally. The other very important concept is the ability for individuals to choose the ways that their data is used, the ways to whom their data might be disclosed. So notice and choice really are the bedrock for so many privacy laws. Now, notice is changing because we can't really provide notice about all the different ways data is used these days. So we need to talk about notice at a much higher level so that individuals have some sense of what's going on with their data and then can make appropriate choices having been appropriately informed. But I think one thing that I just want to note is that it's so critically important that these laws be absolutely clear so as not to hinder innovation. We are innovating in this country a mile a minute, and we should not have laws in place that would hinder that kind of movement. It's just an enormous boon to the global economy. In many countries, there are now restrictions on the cross-border transfer of data. And that means that there are legal obstacles put in place so that you can't transfer data, personal data, to another jurisdiction without jumping through various hoops. Those hoops are purely bureaucratic in nature. They're making good money for lawyers and for consultants, but they really don't, in my view, add to the actual privacy of the data. What really matters is that the companies that are moving data around the world remain accountable for their information practices and remain responsible and are good information stewards.
I want to comment on both the notices point that was just made and also on the issue of progress and innovation. On the notices front, probably the most maligned privacy law is the financial privacy law, the Gramm-Leach-Bliley law, because it requires that companies send a paper notice to everybody who's a customer of theirs every year. And these notices are received and tossed in the trash. I think virtually no one reads them. So the law's it's maligned. There's been jokes about it. It held up as examples sometimes of a completely pointless, formalistic kind of law that just costs money and wastes paper. On the progress and innovation front, it is very interesting today how our desire to support the goal of progress and innovation comes into conflict with the ideal of privacy. So, for example, in the healthcare domain, it is absolutely essential if we're going to move forward with research, say, in the genomic area, that scientists and researchers have access to not just people's healthcare records, which contains this what we call phenotypical information about individuals, but they also need genetic information, whole genome sequencing type information from individuals. Well, it used to be that genetic privacy was held up as one of the most important types of privacy. We even have a special statute that protects genetic privacy, so it is important. Yet, if researchers don't have access to our genetic information and our healthcare records, it's going to be harder for them to do the research they need to find the cures for some of our most troubling conditions, including Parkinson's, Alzheimer's, cancer, and so forth. So we have this real tension between keeping our data private and allowing others access to it in the name of progress and innovation.
Notice and transparency. So let's talk a little bit about privacy and national security. Obviously, Edward Snowden's revelations about the National Security Agency's bulk telephony metadata program raised concerns among many citizens about how the government accesses or has access to our electronic communications. From your standpoint, what do you see as the right balance between privacy law and national security?
We really shouldn't have to choose, Steve. We should have both. The government certainly needs data to keep us safe, but there need to be rules of the road so that the government is following the procedural rules that we as a society have agreed upon so that they can have access to data and that we can also maintain the level of privacy that we think is appropriate in light of the clear security risks that we face. So once those rules are laid down, the government needs to be held accountable for following those rules.
Yes, and for decades, long before the Snowden incident was in the newspapers and on the web, for decades we've had a law called CALEA, under which it is unlawful for anyone to create a mode of communication that does not give the government a back door. There's a national policy, there has been, again, for decades, that government law enforcement must have regulated access to our phone calls, our Skype communications, our email messages, and so forth. It's scary to think about that, but there's been this principle. But we have believed prior to Snowden that the government was restrained in their use and collection of our data. We learned that more data is being collected than maybe we thought. So the real question for us now, and I think that it's absolutely true, we have to have privacy, we have to have security and law enforcement. How can we have those two things? There needs to be more openness, more transparency in this country about the extent to which our communications are being intercepted, monitored, and surveilled. We haven't had that conversation openly yet.
How has the explosion in technological advancement in electronic communications impacted the practice of law, from e-discovery to doing the specialized practice that you're engaged in?
Well, from my perspective, it's changed it dramatically. There's been a sea change. Law firms are small businesses, small or medium-sized businesses. So we need to ensure that we're implementing the same protections that other businesses implement to protect data. So we have to think about the security of our systems, but we have more of a responsibility to protect data because we have other people's data, and that data is subject to an attorney-client privilege. So we have ethical rules that mean that we need to go the extra mile to protect data.
Related to national security, Lisa or Anita, just how vulnerable are we to cyber attacks?
We are extremely vulnerable, in my view. This is at the most nascent stages, this issue. We really have very little understanding how to control the bad guys and the threat actors from getting into our systems. Now, the one thing that I'll note here that is sort of universally understood is that most security incidents occur as a result of simple vulnerabilities that would have been very easy to have fixed. So we need to focus much harder on going after those vulnerabilities. But really, this is a governance issue for companies. This issue absolutely in the last year has risen to the very top of the corporate radar screen. And we see now the C-suite very focused on it and boards of directors very focused on it, as they should be. So we're thinking about the right governance structuring, having somebody senior, a strategic thinker in place to think about the security organization within a company. That organization also needs to have sufficient resources. Security has been really lightly resourced in the past. That is changing in droves now. And really, I think the resignation of the Target CEO and the threat of ouster of 7 of 10 board members put the fear of God into many C-level executives and to boards of directors. So we need to do a better job of combating this very, very real and significant threat. The threat actors are creative, they're organized, they're extremely motivated, and they're very sophisticated. So all of those things play in their favor. And one more thing plays in their favor: they're really hard to catch. Because this is a crime that's essentially faceless, done over computing devices.
Yeah, we talked about privacy by design. We also need security by design. I think you've laid out beautifully, Lisa, what needs to happen. I'm really glad that we here at Penn are teaching privacy law as a course. I've taught it for many years. It's being taught by some of my colleagues now, Professor Yu and others. But it's very important that lawyers be educated about privacy law and also about the security issues that relate to privacy law. There is now a privacy bar, and I'm glad to see so many lawyers are being trained and are learning more about how to become effective in helping their clients deal with privacy and security issues. And finally, I think that the ethical questions that are raised by the practice of privacy law and by the protection of privacy need to be focused on greatly. I mean, everything we do now can risk other people's privacy. We have an obligation, an old-fashioned obligation of beneficence to make sure that we are not being careless and neglectful when it comes to our responsibilities for protecting our own privacy, but also that of others.
So are there any privacy laws you'd like to see?
Yes, I would love to see a privacy law, a new one, or a revision of our Electronic Communications Privacy Act, Title II, a law that really strongly protected our communications. We spend hours a day sending emails, sending text messages, sending tweets, doing Skype communications. We need to believe as though those communications are appropriately protected by privacy rules. And so I would like to see some laws that specifically address contemporary privacy communication technologies and techniques to make sure that when I and others use these technologies, we're safe.
Lisa, what are some of the best practices for companies in terms of data security?
I think we need to think about privacy and security a little bit differently, but they're really two sides of the same coin. So starting with privacy, privacy by design is a great approach. This is not encoded into law anywhere, but it's the way that you can really craft a code of conduct for your company that is overarching and not dependent on the particular jurisdiction in which the data resides. So focus on privacy by design. On the security side, as Anita said, security by design is becoming critically important. It is a governance issue. Security has to be viewed as a very high-level issue within the company. We need to think about having in place up-to-date, really state-of-the-art incident response plans and teams at the ready that are prepared to deal with events. They will happen. The mantra is it's not a question of if, it's a question of when, and that's absolutely true in my experience. We have to have really up-to-date policies and procedures around security, and we need to practice. So many companies are doing tabletop exercises to practice sort of real-life hypotheticals around cyber threats. In addition, our employees and our vendors are huge risks. I don't want to neglect to mention the fact that the ultimate insider was Edward Snowden, but insiders certainly do create a risk within organizations, and vendors really create a huge risk. We could have a fortress-like environment around our own systems, but if the bridge is down over the moat to our vendors who have authorized access to our systems, they're going to come in, and if their credentials are compromised, then there it is. They're in our system that we thought had fortress-like protections. And one last thought that I'll leave you with is that training and awareness of the workforce is critically important. We need to make sure that there is really a great deal of teaching out there of the workforce, because the human link is the weakest. As soon as one employee clicks on a rogue email that allows malware to be downloaded into the system, then it's all over for the company.
And best practices for individuals seeking to protect their privacy and security online?
Well, starting though with the context in which individuals exist at work, for example, companies need very much to invest in privacy and security. Just as you wouldn't, build a new office building and not put locks on the doors, you can't build a company or continue a company without security for your information technologies. It's absolutely basic, and it needs to be thought about that way, not as a luxury or an add-on, but as something as fundamental as having a lock on your door. Everybody needs to have an in-house privacy policy. Employees need that kind of guidance, both to protect their own interest in the privacy of their communications at their computers, but also the company itself has interests which need to be protected, and the company needs to be educated and trained, as was just explained by Lisa. I think that it may be necessary sometimes to bring in outside consultants. If you're a small company, you may not have the in-house expertise to do it right. Well, you have to hire somebody. You got to make the investment to hire somebody to make sure that you know that your system is secure to protect your information and that of your employees. And I do think that that having a plan of action is a good idea. What do you do if something goes wrong? Because something will go wrong at some point. Everybody needs to be prepared to deal with those emergencies, again, as was just said by Lisa. But finally, the whole issue of privacy and security in the workplace, it's a special issue that we didn't talk much about today, but I think it's very important to underscore the need for the employment, in the employment setting, for there to be absolutely crystal clear rules about how the employer will respect the privacy of the employee, and what the employee must do both to protect his or her own privacy, use passwords, change passwords, et cetera, but also what the employee must do to ensure that they don't carelessly expose the company to a cyber attack from the outside.
Well, thank you both for what's really been a fascinating, insightful, and very useful discussion around privacy and cybersecurity. Thank you both. Lisa Sotto from Hunton and Williams, and of course, Professor Anita Allen, Vice Provost Allen from Penn. And we look forward to seeing you in our next episode of Case in Point. Thank you.